City County versus Amber McHenry, case number 24 TRD 819.
Ma'am?
I'm sorry. I'm just trying to get my stuff situated so it's ready here.
Take a seat
I have a
in
question.
this blue chair.
Do I have the
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down in that blue chair.
Do I have the
Sit down.
rights there?
One more time. Sit down. Now you'll answer my questions. Got it? Did you understand all of the rights and plea options that I explained to you?
No, I do not understand.
Okay. Then I will enter no plea to the charges filed against you. Well, let me just explain to you. You are charged, and I do have a signature on the citation which shows you've been served. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs. I will enter no plea to these charges against you. You already have a pending. You already have a pending.
I object.
What do you object, ma'am?
Because I did not enter that plea.
Okay, so you tell me how you would like the plea: guilty, not guilty, or no contest.
First I have to correct the standing, which is I am not the ens legis non degear. I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
The energy in the room shifts the moment this hearing begins, and not just because of the defendant. Imagine being a student on a field trip, expecting a boring lesson on civics, only to witness a grown woman refuse the basic instruction to sit in a blue chair. The judge wastes no time establishing authority, threatening contempt within seconds. It is the perfect setup for what is about to follow, as the defendant begins to treat the courtroom like a debate stage rather than a place of law. This is how you lose a case before it even starts.
Sent in a paper that is my declaration and affidavit of what I want to do, which is to settle the case. I am willing to surrender the person to the court for mutual consideration. I do not want to continue doing this. I don't have anything to do with this. That paper that I signed, which is the summons, is signed v coatis, which is void contract, and I reserved all of my rights on there. So, is the court willing to give me mutual consideration today or not?
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. I do not understand.
I will set this case for a bench trial, and we'll get this set.
I have the right to a trial by jury.
Okay, no you don't, not in this case.
Yes.
Now these are not jailable offenses, ma'am. You don't have a right to a trial by jury in this case. You already have a jury trial scheduled in another case, but then because you're facing jail time in that case. But in this case, you're not facing jail time, only a fine and court costs.
Anything that is above $25 in a court of law has the right to a jury by trial, which is involuntary. Involuntary can't be violated, basically, is what it means. So I have the right to a jury by trial.
No, you don't.
Of my peers.
No, you don't.
Yeah.
We're going to set it for trial, and you're going to go to the clerk's window, and they'll give you a trial date. Okay? So
then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis. nom de guerre. I told you
I don't know what that means either, ma'am. I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever.
As the charges are read, we see the classic sovereign citizen playbook unfold. She moves from a minor misdemeanor for expired plates to an elaborate fantasy about being an authorized agent for a decedent estate. The logic is dizzying, suggesting she is merely a settler looking for mutual consideration. The commentator adds a sharp reality check here, highlighting the absurdity of these anarchist beliefs in a modern legal system. It is a fascinating look at how deep the delusion goes when someone decides that magic legal words can override a signed police citation.
Yeah.
So
Ma'am, if you don't leave the courtroom, and if you don't go to the clerk's window to get a trial date, I'll have you arrested and hold you in contempt of court.
With what contract?
There is no contract.
I know
You're looking at the contract. You're looking at the one who's going to be able to, has the authority to be able to put you in jail and I'll hold you in contempt. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested.
So, contempt of court for what? What contempt?
For not doing what I'm telling you to do, which is to go to the clerk's window and to get a trial date.
You're the trustee and I'm the beneficiary.
No, there is no trust relationship here.
No, there isn't.
I've drafted many trusts, and there is no trust relationship between the judge and you, the defendant.
Yeah, because
you are not the beneficiary, and nor am I the trustee.
Yes.
Yeah.
Things escalate as a defendant demands a jury trial for an offense that doesn't even carry jail time. She quotes legal concepts she clearly doesn't understand, claiming her rights are inviolate, while the judge tries to explain that 36 years of legal practice says otherwise. The tension is palpable as she refuses to accept any of the 3 plea options provided. Watching her attempt to navigate the system using a broken compass is both frustrating and hilarious, especially as she declares she is going to surrender the person to the court and never come back.
Go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it?
Is this your phone?
This is the ultimate breaking point. The defendant takes a sharp turn into personal insults, suggesting the judge spends his time eating paint and researching conspiracy theories. It is a bold, albeit foolish, strategy that puts her on the brink of immediate arrest. The judge remains remarkably composed while explaining the basics of a trust relationship, which he naturally rejects. The segment ends with a heavy warning and her departure, leaving the courtroom stunned by the sheer audacity of her performance. This is why you don't use social media theories to fight a real judge.
448 SM, the People versus Eric Martin. Mr. Martin, can you tell me your name?
How much Roman cystic that's what you're wondering.
Okay, I recognize Mr. Martin. Mr. Martin, it's my understanding that Mr. Coots, an attorney, defense attorney, attempted to meet with you to go over your rights and that you did not want to meet with him. Is that correct? Yes or no?
Well, at first I did, and then I kind of changed my mind. I'm still, in the sense of not giving you guys the fraudulent presumption that you got jurisdiction over me.
We shift gears to the return of Eric Martin, a man who seems to have a permanent reservation in the county jail. Despite being released only 24 hours prior, he is already back for violating bond. The judge tries to address him, but Eric is more interested in the fraud of jurisdiction than his actual freedom. The visual of him appearing via video while claiming the court has no power over him is the height of irony. It sets the stage for a repetitive but intense battle of wills between a seasoned judge and a man who refuses to acknowledge the walls around him.
But
So
then
no.
again, it kind of flips too because
I'm going to mute you so I can tell you your rights, Mr. Martin. I need you to listen. So here are your rights. You've been brought to court on an allegation of a bond violation. Specifically, you currently have a domestic violence case pending at this court in front of Judge Slavin. And on that case, the complainant is Kirk Martin. There was a no contact provision. And that was one of the conditions of bond. And there is an allegation that on December 14th, so just this weekend, that someone called from the residence of Kirk Martin and indicated you were in the home. And the officers alleged that you were, that they checked and that you had bond conditions out of this court saying you weren't to be near him. And that you were taken into custody for violating your bond conditions of no contact with Kirk Martin. These are allegations at this time, but they're serious allegations in violation and no contact provision. So do you want me to enter a plea or do you just want to ramble about jurisdiction? I'm going to ask you to unmute so you can answer my question. Officer Ziegler, I'm sorry, can you unmute? Mr. Martin, you have options, so you understand that's what you're here on. You can plead guilty, not guilty, or you can say nothing and I'll enter a not guilty plea on your behalf. So to the allegations that you violated the conditions of your bond for purposes of arraignment, how do you plead?
first I want to notify crimes. Before I get to that, I want to notify crimes committed against me in the jail here since I've been here, such as criminal harassment.
Okay, I'm going to enter a not guilty plea on your behalf.
I'm not going to talk
But your answer is non-responsive.
Violating my First Amendment right, freedom of speech. And this whole bond order condition, it violates my due process right to be free at my house, which is based on an unsupported lying allegation by my brother. Therefore, this is all violation of my due process rights. The bond order should have never been done. This is all unconstitutional. The case should be dismissed, and I demand to be dismissed.
The details of the violation come to light, involving a domestic violence case and a no-contact order Eric allegedly ignored. Instead of addressing the facts, Eric pivots to his First Amendment rights and claims of criminal harassment within the jail. He demands the case be dismissed with the confidence of a king, despite being in the weakest position possible. The commentator comparison of him to a 50-year-old toddler is spot on. You can see the exhaustion on the judge's face as she enters a not guilty plea on his behalf just to keep the process moving.
You have a right to a hearing on this matter. You have a right to receive written notice of the violation. You have a right to plead guilty, not guilty, or stand mute. I've entered a not guilty plea on your behalf since your response was non-responsive. You also have a right to contest the charges at a hearing. You do have the right to the assistance of an attorney at all subsequent court proceedings, and you can change your mind at any time, Mr. Martin. You have the right to have that lawyer appointed at public expense if you are unable to afford an attorney, and it's always possible that if the court determined you were able to pay, that you would be required to contribute to that cost. If you continue to proceed without an attorney, you would give up your right to a lawyer's assistance. We will set the hearing. I'm required to set that hearing on that violation. If you are in custody, we must hold it within 14 days of the arraignment, which is 14 days from today, or the court must order you released pending that hearing. If the alleged violation is based on a new criminal offense, that is basis for separate criminal prosecution. I don't have any knowledge that that's the case here. The court could postpone the hearing for the outcome of that prosecution. You have a right to contest the allegations against you. You would have a right to have the evidence against you disclosed. You'd have the right to present at the hearing or to be present to present evidence and to examine and cross-examine witnesses. The court would only consider evidence that's relevant to the violation, but it need not apply the rules of evidence except those pertaining to privilege. The prosecuting attorney would have the burden of proving the violation by a preponderance of the evidence. If you pled guilty, you'd be giving up your right to a contested hearing. And while this case is pending, you could be, the most severe violation is you could be held pending the hearing, and if found guilty of this violation, you could be held while this case is waiting for jury trial. So those are your rights, Mr. Martin. Mr. Martin, I understand your sovereign arguments. I mean, it's fine. You can make them. I've heard them before. Everyone at this court has heard them. But here's the thing. I can't have you, if there is a no contact order and you continue to violate the no contact order, I can't let you out because you're not listening. And I know you don't think.
This part highlights the procedural patience of the court as the judge painstakingly explains Eric's rights, including his right to an attorney and the rules of evidence. Eric, however, isn't interested in a fair trial. He is interested in a platform. He continues to ramble about due process, while actively experiencing the very process he claims is missing. The judge's explanation of the 14-day hearing requirement is a reminder that the law works for everyone, even those who spend their entire lives fighting it with nonsensical arguments and repetitive demands for release.
Okay, well, this is in accordance with the Constitution, and okay.
And the fact of the liberty right to be home because of an unsupported lying allegation. I'm telling you right now, he told a lie. And I told the prosecutor my brother assaulted me in actuality. First and foremost, he assaulted me. But I have no evidence of it. I don't have him on video evidence. He doesn't have me on video evidence to assault him. So we have my brother saying this, me saying this. We don't know what happened in reality. So the dumb cop should never arrest me. Prosecutors should not be moving forward on this. They're moving forward with it. It's already a malicious prosecution on the prosecutor's part. There's no probable cause because there's no evidence here. Bottom line, we don't know what happened. This is violating my due process rights. I'm being deprived of my freedom to be at the house I've been living at for 32 years. The bond order was legally should have never been ordered because it's based on, once again, an unsupported lying allegation that has no video evidence, no real evidence to support it. The bond order must be dismissed. I'm supposed to be allowed to go back home where I have a right to be. Doesn't matter how many lies are told.
Let me tell you your bond conditions, Mr. Martin. You're to appear in court as directed. All right, I'll mute you and read them. Whether you like them or not, these are your conditions, sir. So I'll just read them into the record and you can choose to listen or not listen. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Whether you like it or not, you're not to have any contact with Kirk Martin or the residence where he resides and where this original allegation occurred, which is 9074 Clippert in the city of Taylor. Sir, you cannot purchase or consume alcohol or illegal drugs. You can't possess or have access to firearms. And you have a $2,000 cash bond. I've noted on the file that you're entitled to this hearing forthwith, so the clerks will give you a date forthwith. And we're all set. Thank you.